Hello and welcome to this presentation on ACs 1.2 and 3.1, where we are describing the organisation of the criminal justice system in Wales. And today we are going to focus on the role of the Crown Prosecution Service, the CPS. So, by way of an introduction, what does the Crown Prosecution Service do? Well, the answer's in its name. It's responsible for prosecuting people in England and Wales who've been charged with a criminal offence. It was created in 1985 under the Prosecution of Offences Act. Prior to 1985, decisions on whether to prosecute people were made by the police, and it was decided it was in the best interest of the public and in fairness for that to be removed from the police and for that to be taken over by an independent body, the Crown Prosecution Service. So, as I've stated, it's an independent judicial agency, which means it's made up of legal experts, but it's independent from the police and independent from the government. The head of the CPS is known as the Director of Public Prosecutions. At the time of writing, this is Stephen Parkinson. There he is. And there's also a government minister who he answers to. And at the moment of time, that is Richard Hermer, KC. So Richard Hermer is the government minister who has overall responsibility for the CPS, but the CPS is run by the Attorney General, who is Stephen Parkinson. Our current Prime Minister, Keir Starmer, used to hold the role of Director of Public Prosecution. So before Keir Starmer went into politics, he was head of the Crown Prosecution Service. Okay, funding, it's funded centrally by government, so it comes from taxpayers' money. Basically, in the 2024 to 25 year, it received approximately £751 million. And it can recover some of that money through costs, by charging for costs. So when you hear of courts asking defendants to pay costs for the case, there they are paying for the cost of the trial, and that money goes back to the CPS. At the same time, assets that have been confiscated from criminals, selling those off is put back into the purse of the CPS. So the latest figure I could get, couldn't find the one for recent years, but in 2021 to 22, they recovered about 40.7 million, but the data is no longer published. So 40.7 million out of, assume it's gone up a bit since 2021, let's assume it's about 45 million. So they're getting a little bit back, but not masses. Okay. If you want to watch a YouTube clip, this link here will take you to a clip that explains the role of the CPS, but I'm going to do it for you anyway in this slide. So basically how it works is this. When a crime is reported to the police, they carry out an investigation into it. Sometimes, in more complicated cases, the CPS will offer the police early advice, such as what kind of evidence to look for to help them build the case. For less serious offences, once the police have completed their investigation, the police will decide whether or not to charge the suspect with an offence. For more serious offences, once the police consider they have enough evidence, so for more serious offences, going back to my PowerPoint on the police, I gave some slides on what offences the police can charge suspects with. But for the more serious offences, the police will go to the CPS. They hand the case and the evidence over to the CPS. And it's the CPS who make the decision about whether a suspect is to be charged or not. So the sort of cases that will be handed over, more serious offences, hate crime, domestic abuse, anything that carries a sentence of more than 6 months in prison has to go to the CPS. And So the CPS are advising the police of their investigation, such as what evidence is needed to build a case. They then, once for the more serious offences, once they've got the evidence, will assess that evidence that the police has submitted to them. And once they've looked at that, they then make the decision, not the police, whether or not to prosecute, and also under what charge the prosecution will be. So they might look at the evidence and go, do we have enough for a murder charge? Should this be manslaughter? And it's they that make the decision on the charge. And it's them that will tell the police what to charge the offender with based on the evidence that's been submitted to the Crown Prosecution Service. Once the charges have been made, it is the Crown Prosecution Service that prepare and deliver the case to the prosecution. So they prepare the case, they present it in court, it's their lawyers that prosecute criminals in court. Sometimes they'll employ some self-employed specialists, but generally, if it's a prosecuting barrister, they will be working for the Crown Prosecution Service. And they also have the role of assisting and supporting victims of crime and prosecution witnesses. So if you get a question on the role of the CPS, these two slides will help you a great deal. But quite often, or the most common question that comes up in exams concerns the next few slides. And that is how the CPS go about making the decision to prosecute. How do they decide whether to prosecute or not, and on what charge? And the process by which they do that is called the full code test. Comes up pretty regularly. You need to know this in detail. So let's go through it bit by bit, and I'll explain it as we go. So the police have done their investigation. It's a serious offence, so they can't make the charge. All the evidence is handed over to the CPS, and the CPS will look at that evidence and will decide what charge to bring at the end of it. And this is called the full code test, which has two specific stages. So first and foremost, the CPS start with stage 1, which is called the evidential test. And in the evidential test, they are going through, is there enough evidence here for a realistic prospect of convicting the subject? In other words, are we likely to get a guilty verdict? Is there a realistic prospect of getting a guilty verdict if we take this case to court? Now, not guilty beyond all reasonable doubt, which is what a jury will be deciding in a high court, but realistic chance of getting a guilty verdict. They then check the evidence itself. They check to make sure that it's admissible. In other words, was it collected properly? Was it stored properly? Has it been contaminated or not? Making sure the evidence isn't hearsay, in other words, he said, she said. Is it reliable? Is it credible? Is it believable? Are the witnesses reliable? Are the witnesses credible? Etc., etc. If they think that is the case, then they will go to the next stage. If, however, they do not think they've got enough evidence, or the evidence has been contaminated, or the witnesses aren't reliable, they will drop the case, because it's public money that is being spent on these cases, and it's expensive to take a case to court. So if the test is satisfied, then and only then do they move on to stage 2. And stage 2 is called the public interest test. And the key thing behind that is it's taxpayers' money that's being used to fund the CPS and take these cases through the court system. And this test is really saying, well, are we using this money responsibly? Is this a good use of taxpayers' money? Is it in the public interest? So once they've worked out that there's enough evidence, they've then got to decide, is the prosecution in the public interest? And they'll consider lots of factors for and against prosecution. Some factors may increase the need to prosecute, and others may determine that another course of action is better, not prosecuting. But a prosecution will usually take place unless there are public interest factors against it, which clearly outweigh those in favour. So if that is the case, and it is in the public interest, they will continue to prosecute the case. Now, the sort of factors they may consider when thinking about is a case in the public interest are some of these. So they might say, well, how serious is the offence? If it's a very serious offence, they're more likely to prosecute. If it's not so serious, they're not. What is the level of culpability? What's the level of blame? How much is the person to blame? How much harm has the victim suffered? The age and maturity of the suspect, they're not the same. You can have a 21-year-old with the mental age of a 10-year-old, and vice versa indeed. The impact the offence has had on the community may be a contributing factor to what they decide whether it's in the public interest or not. Whether or not a prosecution is a proportionate response to the offence. So I think here it's like sledgehammer to crack a nut. Or whether information sources require protection, in other words, in relation to other investigations. So, for instance, they may decide not to prosecute a drug dealer in return for that drug dealer giving them information about people higher up in the chain. Now, the sort of thing that I'd use here, and a good example is our laws on assisted dying and euthanasia. Because even though at the moment laws are going through Parliament to look at changing the law on assisted dying, the reality is that our current law states at the time of doing this presentation that if you assist in the suicide of someone, you can be prosecuted. So let's say you go to Dignitas in Switzerland, which allow you to kill yourself by drinking a concoction of various mixtures that paralyze you, stop your heart and put you to sleep. If you go with your partner to Dignitas and you help them over there, and you help them to travel, let's say they're paraplegic, quadriplegics in a wheelchair, you assist in getting them over to Switzerland, and you're present when they drink the potion that kills them, technically you have broken the law. Technically you've assisted in the suicide of a person. And these euthanasia incidents are always filmed. So there's plenty of evidence to show that you are guilty of that crime. And yet, to my knowledge, no one has ever been prosecuted for that. So it passes the evidential test. There's loads of evidence to say that you assisted in that suicide. However, when the CPS look at it, they go, is this a good use of our money? Are we likely to get a guilty verdict? And in the case of Kay Gilderdale, which I'm sure some of you will look at later on in the course, a jury found her not guilty, even though she was clearly guilty. So public opinion is divided on that sort of thing, and that's a good example of how perhaps the public interest test is used to not prosecute. Okay, let's move on to the last little bit. So, occasionally, in limited circumstances, the full code test is not met, but they still want to charge a suspect. They will apply the threshold test. Now, this is going for A-star stuff here if you get a 9-mark question on it. Otherwise, you might not need to know this slide. But they will look at the threshold test. They will take the seriousness of the circumstances of the case. It's going to be a really serious case, and it's got to justify an immediate charging decision. And there's got to be really good grounds to object to bail. So this is where the police want to hold someone on remand, keep them on bail, charge them so they can't get them, so they're not out in the general public. They don't have quite enough evidence to charge under the full code test, but they're pretty sure they're going to get some pretty quickly, and they want to make sure that the person is locked up behind bars and can't do a runner, or alternatively, do a runner is released and then destroys vital evidence that would lead to a prosecution. So there's going to be really good grounds to object to bail. And there's two real scenarios where the conditions for each must be met. So it could be, as I said, further evidence is being obtained to meet the evidential state of the full code test. So there's going to be reasonable grounds that the person's going to be charged. Pretty sure you're going to get enough evidence. And secondly, it's not appropriate to apply the evidential stage of the full code test due to outstanding reasons within the inquiry, the seriousness, the circumstance of the offence. So even after that, you know, we're a democracy. You can't just keep someone in jail under the threshold test. It's reviewed constantly on a weekly basis, and if they don't get the evidence, the person has to be released. It's as simple as that. So that leads us on to our final slide. As ever, it's how do the CPS work with other agencies. Now, obviously, since 1985, the CPS have made the charging decisions on the more serious crimes. Prior to 1985, the police made all those charging decisions. Although when we're talking about how they work, what's the relationship between the police and the CPS in terms of an exam question, we talk about how they work to each other. It would be true to say that sometimes the how they get on, which will never be what you put in an exam answer, can be quite fractious between the police and the CPS, because the police do a load of work, gather loads of evidence, give it to the CPS, and the CPS turn around and go, no, we're not going to prosecute. And that can lead to some frustration between the two agencies. So I picked out this sort of comedy poster police jargon of what the CPS stands for: Criminal Protection Service, can't prosecute sorry, couldn't prosecute Satan. So it gives you an idea of sometimes how the police feel. But in terms of their relationship with the police in answering an exam question, the CPS advise the police on possible lines of inquiry and what evidence they need to build a case, and then on more serious cases will instruct them on what to charge the suspects with. They also work with the courts because they prepare and present the prosecution case in court, and they also present and prepare cases to the appeals court if they think the judge has awarded an unduly lenient sentence. And those are really the only two people they work with. And I've just put right at the end of this presentation, all criminal cases in this country are entitled the Crown versus the defendant. The law is not a law until it receives royal assent, as we saw back in AC 1.1. So therefore, the CPS are bringing the prosecution on behalf of the monarch, on behalf of the Crown, against the person or persons that have broken the monarch's law. Hence the title, the Crown Prosecution Service. I hope you find that useful, and I will see you soon for another video on these ACs. Have a good day.